Adjournment request, if any, from item number 1 to 6.
May it please your lordship. Lordship, I beg to mention item number 6, 7, 8, and 9 of today's list. May I pray for taking up the matter after 2 weeks, lordship?
August. Yes.
From item number 10 to 17.
Lordship, I beg to mention item number 11, Lordship. Kindly pass over the matter for the day.
Delay condonation application.
Yes, Lordship.
You are for?
For the applicant, Lordship.
Why you are asking for adjournment?
Lordship, my senior is out of station, Lordship.
You come and argue. And the number comes, come and argue.
Please, your lordship. For item number 10, my lord.
Yeah.
The delay continuation petition, my lord.
Let the number come.
Yes.
Let the number come.
Yes, my lord.
Wait for your turn.
Adjournment request from item number 18 to 24.
May I please, your lordship? Lordship, I have to mention item number 14, lordship. Lordship, kindly pass over the 1-4.
Yeah. July.
May I please, my lord? Could read the request?
Lordship, in the item number 16 of the daily cause list, I filed an additional affidavit just yesterday.
Here's your gown.
I'm appearing in person.
Person. Item number 16.
16. So I will file a requisition slip to bring it on record.
May I please, my lord? With regards to item number 19 and 20 of the daily list, my lord. Departmental instructions have been received, my lord. I'm praying for 2 weeks' time to file our affidavit in opposition, my lord.
Item number 19 and 20.
20, my lord.
Yeah.
Your
Applies, my
lordship, there is an interim order. Interim may kindly be extended, your order.
Interim, if I need to, till next.
Oblige, your lordship.
May it please your Lordship. Lordship, I'd like to mention item number 22 and 23. Lordship, may kindly grant me some more time to file my rejoinder, Lordship.
Now the period is over.
Lordship, may kindly grant me. I've already informed the other side. Lord.
Okay.
Much obliged.
Any other request?
Lordship, I beg to mention item number 27, Lordship. This matter may be possible for 2 weeks, Lordship.
August.
Lordship. May I please, your Lordship? Also, I'm making a prayer on behalf of the petitioner in person in item number 28, my lord. My lord, there was an opportunity was given to the other side to file their counter, my lord. They have not filed, my lord.
August.
Mobilized.
Daily list for orders item 1.
Your lordship.
You're supposed to file an affidavit.
Exactly, your lordship. Unfortunately, my client is in a remote place. He was not able to come. However, your lordship, I have discussed with him that it may not be necessary to file the rejoinder and we may continue, but I humbly submit your lordship may allow me to file a compilation, your lordship. And please hear the matter maybe day after tomorrow, your lordship, if possible.
Day after tomorrow.
I know you are very busy, your lordship.
Day after tomorrow, I have some other engagement.
Okay. So any short date, your lordship?
Yeah, suggest which date.
First week, any date, your lordship?
First week, only 2 days are there.
Any of those 2 days, Your Lordship.
7th of May.
7th of May, Your Lordship. And the
7th
other
of May.
side also may submit a compilation if they so desire, Your Lordship.
Item 2.
He was not a party. Leave to appeal पूछा हमने.
नहीं, application नहीं. Six and seven notes, who is appealing for the 6 and 7?
6 and 7. 6 is the school matter I can appeal.
Master.
7.
7.
Otherwise, my lord, he was not a party in the writ petition.
Hmm?
He was not a party in the writ petition from what I find.
He was not a party.
There is no prayer for leave to appeal, if I'm not wrong.
Leave application is not there.
Leave to appeal, we have not been served with, only the IA for the condemnation of delay is there. Otherwise, there is no other IA shown in the cause list also. So perhaps there is no prayer for leave to appeal.
Asked for the time being.
Let's. Time being.
Item number 3.
May I please, Lordship, this is a delay condition application, my lords. Delay is of 67 days. Agreed by an order passed by Honorable Single Judge, my lord, that dated 17/7/24. my lords.
Appeal.
আপুনি আহিছে। Yes.
By the way, come on, madams.
Yes, ma'am.
Yes. And come to the grounds of the appeal. Here for the Assam University,
Assam University.
the grounds of the.
Page 8, my lords.
See.
The husband of the petitioner, my lords, he was serving.
Yeah, facts we are aware,
Yes,
come to the grounds.
ground, my lord,
foremost ground is, my lord, that the person, his employment was temporary in nature, my lord, subject to.
Read the ground.
My lord, ground number B is actually our ground.
Ground number B, come to
B.
the ground.
We have actually complied. A lot of 70% we have complied.
You have not
Certain component remains, my lord, which we
So
cannot
you
pay,
are
my
not-
lord.
You have not obliged, it is your duty to
My lord.
comply.
So, well, no, certain component of that payment, my lord, has to come from the state
Sir,
government.
How you are dependent upon the funds provided by the Assam government, under which provision the learned single judges already discussed all
My lords.
things. And find nothing, your contention has been rejected.
My lords.
What do you want to say about that contention?
My lord, that issue is settled by the learned single judge. Our contention is, my lord, since there's a payment has been directed to be made. But my lord, 75% of that payment we have done. But other 25%, my lord, we have to depend on state government.
How? That is what the.
But
learned
that's
single
fine, my lord.
judge-
My lord will come to the delay condition
Come
application, my
to
lord.
the- come
We
to
have-
para number 6. Para number 6 of the interim judgment.
My lord.
There is no answer to that.
My lord will come to my application, my lord. The delay condition application, my lord.
Delay
There's a communication my written to the government, my lord. Because that for that
Sir,
fund we have to
that
depend on
is-
them, my lord.
That is what you have mentioned in the appeal itself.
My lords.
Okay, and in the appeal, you have filed the appeal only for the reason since there is a sort of the contempt. That's why only you have filed appeal. Otherwise, there is no challenge in the petition.
My lord
This
is correct.
appeal.
My lord is correct. But that component, my lord, we cannot pay. We don't have the funds.
You have to pay.
No, my lord, for that, my lord, state government has to be moved. We are writing letters to the
This
state
is-
government.
This is between you and the state government. If the state government doesn't give you, give it from your funds.
My lord, if the state government, which is also a party, my lord, party respondent in my petition, my lord, appeal.
So what?
My lord, if they are given a certain direction,
Why should we give them the direction, sir?
my lord, if they don't,
Sir, we are here.
lordship is very correct. We are scared of that sort of
We are
contempt,
hearing the later patent appeal.
my lords.
What is the jurisdiction in that? We have to see whether the learned single judge has committed any illegality or not, which we don't find any.
My lord,
The
Lord
matter
Single
ends
Judge,
here.
always he was correct, my lord, but only that issue that because we are dependent on the funds of state
That is-
government, that issue, my lord,
that contention has already been rejected by the learned single judge in para
that is the
number
reason we
6.
are here, my lord. That is the reason we are here.
So what is the material which shows that the state government is responsible for that? Where is that, what is the material?
My lord, basically these are,
Not a single ground in the
my
petition
lord,
that on account of these provision, the state government is responsible to give this fund.
my lords.
Not a single ground.
My lord, the ground is there, my lord, one ground.
Read. May have missed it.
Ground C was there, my lords,
Okay, read.
that the honorable single judge failed to appreciate the post in which the husband of petitioner was serving was temporary in nature and would only exist till sanction was same is continued with the ICAR. My lord, the ICAR stopped
Not
it.
the even plea before the learned single judge. Altogether.
And my lord,
you-
ground A, my lords. Ground number A. Basically,
Ground
that
number
is
A, read the ground number A.
our difficulties, my lords.
The ground number A is only raised since the government has not released the.
Yes,
we
my
are
lords.
Unable to pay. You have not said.
We have
are
paid
not
whatever we
entitled to
can, my
pay.
lords. We are not denying that complete liability. We
Don't
have
deny
paid
that
whatever we
pay.
can,
Pay. It is between.
but a
you
small
and the
component
government.
is there,
How this person is responsible for that?
my lords.
It's
But the-
between you and the government. How this person is responsible
But
for
my
that?
lord, there's a time frame here in the judgment, my lords. But if we don't comply with that, if the state government keeps on pulling it,
Take the matter with the state government, how we are concerned and how this poor lady is concerned for that.
my lords. Only difficulty is that funds are not forthcoming, my lords.
So that is between you and the state government.
That point was,
Pursue the state government. If the funds are not coming, sell your property.
My lord, we are university, my lord.
University, that's why only you are.
Admin, sir, other government
In
department, my
other
lord.
states, in other states also, for the pensionary benefits, they are regularly selling their land and etc. They are doing it. Where the liability is not of the state government and is of the university. That's why only the every time the state government as well as the other institutions are urging the universities to generate the revenue.
My lord, these persons came to us, not through us, my lord. ICAR advertised everything, my lord. They undertook the payment. I'll leave it to lordship, but my lord, the entry of the
Leave it to- What do you mean by leave it to?
I'll leave it to lordship. I was very much.
We are
Time
very
frame is there,
clear
my lord.
not to leave it.
The government has to be directed, my lord.
Not at all. We are not supposed to be here to review, having a judicial review of the Learned Single Judge order. What's wrong in that order? You show us. And from your appeal, there is no ground even.
Appeal, my lord, there
We
is.
said it's like you are filing a reply to the contempt petition. They will not be able to comply, sir, for this reason. This is what the appeal is. And for this appeal is not maintained.
Then we have to file appropriate remedy, my lord, will allow us to withdraw this.
After attempting to argue the matter for quite some time.
Perhaps we have to go for review, my lord.
Okay, matter comes upon for consideration of the application number so and so. With a prayer. To condone the delay in filing. Condone the delay of 67 days in filing the connected writ appeal. So, since the matter. Since the matter involves a short controversy. We have decided to. Hear. The parties. We have decided to hear the counsel for the parties on merits. Full stop. The respondent approached the writ court with the prayer to issue a direction to the appellant university to release the terminal benefits standing in the name of her late husband. As her repeated approach to the appellants for releasing the terminal benefits has not been given any heed by the appellants. Full stop. The learned single judge, after hearing the, after taking into consideration the pleadings as well as the material available on record, has rejected the contention of the appellants that they are not entitled to release the terminal benefits of the husband of the terminal benefits to the respondent standing in the name of her late husband. The learned single judge has rejected the said contention, has refused to accept the stand of the appellants while making the following observations. Para number 5 and 6. 5, 6 and 7. 5, 6 and 7 of the impugned. Full stop. The counsel for the applicant, Assam, applicant, Registrar Assam Agriculture University has failed to point out any error in the impugned judgment passed by the learned single judge. In such the impugned judgment dated 17/7/2024 passed by the learned single judge in writ petition number 6836/2023. In such circumstances, we don't find any merit in this case. Hence, the IA as well as the connected writ appeal, which is yet to be registered, are dismissed. However, the applicants are at liberty to avail appropriate remedy available to them under the law.
My lords. Obliged.
Item number 4.
May please, your lordship. It's an application for delay condemnation of 53 days.
Application for delay condemnation. Indian Oil Corporation.
Yes, your lordship.
What about this writ appeal number 6/2019?
Lordship, our entire case is that
6/2019.
Yes, your
What
lordship.
happened?
6 of 2019 was on the basis of employment notification of 7/4/1995, the basis on which this honorable court had proceeded to allow
It
the
was
benefit of
also
remuneration.
Compassionate appointment in 6/2019.
That was true, but it was not out of that employment notification. Our entire case is that these appointments were prior to that employment notification
Apart
based
from that, from how many years they are working?
95. But on 95,
95, how many years?
it will be now 30 years now. That is true, your lordship, but the only fact
That is
is,
true, then
but that will not
matter ends here.
that will not
Matter ends-
directly confer a right of regularization upon them.
Matter
It-
ends here.
The lordship says it ends, it ends. I
Ends.
cannot better that. But then
Naturally,
but only one aspect. In that matter, 2006 of 2019, IOC had went to the Supreme Court. Though Supreme Court didn't interfere.
6/2019. You approach in 56/2019.
No, no, 6 of
Not in 6/2019.
this to what? The 6 of 19.
6/19, you have not, you have accepted that decision.
There. Hold on,
Till date, no SMP has been filed against.
please, your lordship. I'll just
Writ
read.
appeal number 56/2018. That was.
I'll just please. SLP 18810 of 2022 was filed. Within this honorable court, or Supreme Court,
Against judgment of which, against.
Deepak
judgment
Bhuiya,
passed in
6 of 2019.
6 of
120.
Page 129 of the writ appeal, if your lordship will kindly see. Supreme Court did not interfere, but the question of law was kept open
Again, we'll also keep it open. We'll
for
also
us
keep
to
it-
proceed there.
We'll also keep it open.
My entire contention is that those judgments were passed basing on that employment notification, wherein a process of selection took place. But herein, there was no process of selection. They were purely on compassionate basis, they were given appointment on an application made by them.
15. 3 petitions,
3 petitions. 4, 5, and then
15.
15.
I am appearing for respondent 1.
Thank you.
Lordship will keep that question of law open.
Question of law is open. The Supreme Court has kept it open.
I understand, Lordship. I understand. Yes, yes, obliged.
Matter comes upon for consideration of that. IA number 79/2025. With the prayer, condone the delay of how many days?
53 days, Lordship.
53 days in filing the connected writ appeal. Full stop. इनमें दोनों में अलग अलग ऑफर ये नंबर 93 एक तो 979 हो गया एक नेक्स्ट 5 नंबर है 93 दोनों में सेपरेट ऑर्डर the notices of the IA has already been has been duly served upon the respondents and Mr. So and so is appearing on behalf of the respondents. Stop. Having gone through the contents of the application after hearing the learned concept of the parties, the delay in filing of the connected writ appeal. Delay of 53 days in filing the connected writ appeal is condoned. IA is allowed to stop with the registry is directed to register the connected writ appeal listed immediately. Full stop. इसके बाद में उसको एक अंदर with the consent of the parties matter is heard finally.
Yes.
ये तो मैं तो finally का will accept it. And 15 में with the consent of the parties the matter is heard finally.
Obliged. Obliged.
Item 10.
Mr. Counsel. That judgment in writ appeal number 58/2016 and another
Yes, sir.
judgment 9 oblique this 6/2019, please supply that copy.
Yes, sir. Answer.
And the
It's
Supreme Court
already annexed in the writ appeal, but separately I will just place it for your lordship's convenience. I'll be back.
and the Supreme Court order also. Yes, you are for the finance department.
Yes.
Yes. On merits.
Yeah.
One day regularization.
My lord,
And Supreme Court has disapproved that.
no, actually, beloved, I continuously served for 30 years, beloved. And
It's unfortunate. but,
I was also entitled for regulation as per the government policy. But by mistake, they did not regularize my
What
service.
do you want to say on condonation of delay? Mr. Nayak, what do you want to say on condonation of delay?
Lordship, in my submission would be, even if that is condoned, Lordship, in on merit, Lordship, this is not a case to be interfered with.
Can the matter comes upon for consideration of the IA number so and so and so. Mr. Dina is appearing on behalf of the respondent number 1, 3, 4, and 5. Mr. N. Das. Yes. No. Mr. Zonso is appearing for the respondent number 2.
I'm
Mr.
here
Nayak
for
is appearing on
6.
behalf of the respondent number 6.
Yes.
And Mr. C. Barua is appearing on behalf of the respondent number 7. Service is therefore complete. So the application for condonation of delay is not previously opposed by the counsel for the respondents. Having heard the learned concept of the parties and after going through the contents of the application, we deem it appropriate to condone the delay of 142 days in filing the connected date appeal. Hence, the IA is allowed the delay of so and so days is condoned. Registry is directed to register the connected date appeal and list for the list for admission after 4 weeks.
Item 11.
Be allowed to file objection, Madam. I will be allowed to file objection in this case.
You may be allowed to file.
Objection in it.
What objections?
That it's legal. This order has been passed.
But the decision bench has already given similar relief to the identical person. Then
That,
he is required to get the benefit, he is required to get the benefit from 2015 instead of 2018. The division bench has had. What remains there?
on the other hand, this petition is also not maintainable, my lord.
Huh?
This petition is also not maintainable. The writ appeal is not maintainable.
Why?
My lord, in this case, my lord, petitioner has filed appeal against the order dated 2019, my lord. I'm claiming similarly in respect of the order which is passed in 2021. My lord. In this case, and the appeal, when the petitioner also have been filed this appeal, my lord, at that time, the writ appeal 2021 is not in existence, my lord.
So,
My lord, this petition is not maintainable.
that's all.
Yes, sir.
The matter comes upon for consideration of the IA number so and so with the prayer condone the delay of 970 days, 71 days in filing the connected writ appeal. Stop. The net counsel appearing for the respondent, though have not filed any written objection to the application for condonation of the delay, but as opposed the application while stating that oppose the application while arguing that no sufficient cause has been given in condoning the no sufficient cause has been offered to condone the use delay of 971 days in filing the connected writ appeal. Stop. We have heard the learned counsel for the parties and after and also peruse the contents of the IA number so and so so and so. Stop. It is to be noticed that in a case of similarly situated persons, person, the division bench of this court in writ appeal number 18 of the 2021 has granted indulgence and has ordered for granting the benefit of pension from the date of retirement instead of date of passing of the impugned judgment by the learned single judge. Instead of year 2018. Instead of 4/12/2018. Yes. In such circumstances, we are of the view that the delay in filing the delay of 941 days in filing, it's a 971 days, 971 days in filing the connected writ appeal is liable to be condoned. The IA is therefore allowed, the delay of so and so days is condoned. Ministry is directed to register the connected writ appeal immediately. So after that, with the consent of the parties, matter is heard finally. Close for orders.
Let's look at your place.
And you are seeking adjournment.
For admission, item 12.
May I please, Lordship, what is your explanation? My lord, I have received instruction, Lordship, I pray, my lord, some 2 days time. I have received. Okay, and Mr. R.T. Bora, then the concept appearing for the respondent, please some more time to. Clarify, to comply with the order dated 20th of February 2025 and 19/3/2025 passed by this court. Time period who is granted list after 4 weeks. Interim order passed by this court on 20th of February 2025 shall remain in currency till next stage. I am obliged.
Item 13.
I'm sorry, my lord. The similar case has been dismissed, my lord. But the law is different, my lord. I
You are
want
not
to,
supposed to be sorry, we are sorry. Similar case has already been dismissed.
but my lord, I want to place one Supreme Court judgment. The same, the Supreme Honorable Embassy Court has already,
Now we are bound by our judgment. We are bound by our judgment.
yes, but my lord, my case was dismissed, my lord, relying on the airport authority, my lord. My lord, there's a perversity of the honorable.
It's not relying on airport authority. Airport authority has simply said, okay, don't interfere in the jurisdiction exercised by the learned single judge lightly. That is the not exactly covered nahi hai. Say, but we have just followed that.
But my,
So whatever the view taken by the learned single judge was a plausible view. And we are not supposed to interfere in each and every writ appeal.
but my lord, it was my fault, my lord, because as per rule, my lord, the fixation of the my lord premium, my lord, as it should be as per rule, and the honorable appeals court held, my lord, it is on individual basis, not the on my lord.
It's not.
So all, it's
You
like,
applied for regularization or whatever it may be for grant of patta in the year, suppose 10 years back. And if that is approved now you can't say, okay, I'll pay for the rate applicable in the year 2000, 10 years back. That is not, that can't be done.
but this my lord, if you allow me to, this judgment, my lord, my well, because my lord, but may I read, my lord, because it's similar to my lord. Paragraph 2, my lord. Paragraph 2, 3, and 4, my lord.
Which this?
4, my lord,
That's all.
my lord, and see, my lord. This is under, my lord, Rule 40, my lord. But my case falls in the tribal belt area under Chapter 9, my lord. And in that settlement, my lord, there is, my lord, the bona fide need, my lord. And the bona fide need amongst the eligibility, my lord, bona fide need, my lord. And my lord, the bona fide need, my lord, bona fide need or bona fide claim or right, my lord. The honor division bench of this court held that, my lord, the length of, my lord, occupation, my lord, the bona fide right acquired, my lord. And my lord, considering that, my lord, the rule has been under the rules, my lord, my entitlement and the bona fide need, and if the bona fide need consideration, then my lord, the rate of zonal value is cannot be, my lord. It's the individual, my lord, valuation of the individual, my lord. Because then if this law is, my lord, settled, my lord, then, my lord, no poor person, my lord, will get settlement, my lord. It will be against the public interest, my lord.
That's all.
My lord, may I place that rule, my lord?
You have considered that rule in the earlier judgment.
I was not properly placed, my lord. I was not properly placed that on that day, my lord.
Yes. Sure.
Chapter 9. Chapter 9 of the rules under the Assam Land Regulation, my lord. This is tribal well, my lord. Rule 1, my lord.
Yes.
The disposal of land within the tribal or blocks constituted under the provision of section 161 of the regulation shall be made in accordance with the provision of these rules. The settlement of wasteland shall be made only with the classes of people notified under section 162 and specified in section 163 of the regulation. My lord, kindly see 162, 163(2), my lord.
Yes.
Section.
Yes.
163, my lord. Oh, 163.
Yeah.
One. The disposal of land in areas in which the provision of this chapter applied for the purpose of ordinary cultivation or purpose ancillary thereto shall be in accordance with such policy and procedure as may be adopted and directed by the state government. In adopting the directing such policy or procedure, the state government shall take into consideration, my lord, kindly see C, my lord. I am fall under C, my lord.
Yes.
I am fall under C, my lord. Thirdly,
Yes.
thirdly, if the extent of cultivable land for settlement in the belt or block the large enough, the bona fide need of the person belonging to other class of people residing in the belt or block from before the constitution of the belt or block. I am fall under this class, my lord. My lord.
Yes.
Then, my lord, subrule 3, the policy adopted and directed under subclause 1 shall also provide and that no settlement with the persons belonging to the classes of people mentioned in clause C of subsection 2 shall be made except with the previous approval of the state government, my lord. The question of approval comes, my lord. Then, my lord, kindly see, my lord, the rule again, my lord. I am on the rule. Rule, my lord, rule 3 of the chapter 9, my lord.
Yeah.
The settlement of land under these rules will be only on written application to the application or the office employed on this rules and so any office employed to the application enter application on this behalf, my lord. On receipt of the application, the application or on application deputed by the officer on this behalf will inquire into the availability of the land and the claims of the persons entitled to obtain the settlement. Then in making settlement of land, the provision of section 163(2) shall be strictly followed and settlement shall be made for each class of people in compact blocks so far as possible. Then, my lord, kindly see, my lord, 7 rule.
Yes.
The land settlement on annual lease may be converted into periodic lease when the conditions prescribed in rule 105 on the land records manual are fulfilled, my lord. This is one of the conditions, and the requisite premium, if any, fixed by the state government has been paid, my lord. Here is, my lord, the if any, my lord. There is no that the fixed or time to time rate. Here is something different from that, my lord, because it's the bona fide need, my lord. If you lord, for a moment, my lord, if your lordship kindly see rule 15 of the land records manual, the crux of the matter there, my lord.
Yes.
105 of the land records manual, my lord. Flat, my lord, I have.
Yes.
Language manual.
Yes.
The condition to be fulfilled are as follows, my lord.
Yes.
Rule 1 not required, my lord. B.
Yes.
The land must be actually cultivated with some permanent crops such as planted rice or permanent vegetation which twice or permanent residential or permanent cold weather crops or occupied for permanent resident purpose, my lord. my condition fulfilled because since 1947, I am residing on there by my lord. And my lord, kindly see rule 3, then sub-rule 3. Notwithstanding anything contained in the foregoing parts of the rule, no new periodic purchase shall be proposed or ordered to be issued for lands within an area covered by a mining lease or situated within a town area, because this land is within the town area, my lord, or within 2 miles from the town area or within such distance from the town area as may be notified by the estimate from time to time, except under special orders of the government and on payment of such premium, if any, as may be fixed by the government from time to time, my lord. The similar rule has been for Rule 40, my lord, which has been interpreted by this Honorable Apex Court, my lord. But my liability, my land fall under the town land, my lord, and tribal land. I am all along, my lord, eligible, and my lord. Therefore, the premium should be fixed on the individual. Yes, my lord.
On the date when you applied for that.
No, my lord. On the not date, my lord. Not, I am not saying the date, my lord.
Then
the value of the plot of the land in question, my lord.
okay, on which date? Relevant date is
because, my lord,
relevant date is when you applied for settlement.
Because this question comes, my lord, the Rule 105 of the Land Record Manual. And kindly see, my lord, one thing, my lord. My lord, just 105, sub-rule 1, sub-para 2, my lord.
Yes.
All applications for conversion should be inquired into and disposed of as far as possible within a period of 3 months from the date of receipt of the application, my lord. Within 3 months, when my liability comes to pay the, my lord, premium, then the same rule says within 3 months time frame, within time frame. So obviously, my lord, the zonal valuation or the fixation of the separate rate does not come. It means, my lord, individual
to that 3 months one.
3 months. Then is it there is two conditions, my lord. One is upon the government 3 months and liability to me, my lord.
To pay on the date when the rate was applicable on that date. The premium was applicable on that date, you are supposed to pay from that date only. Even though if the approval is granted at a later date, but you are supposed to pay on that date.
My lord, because when not my lord, I'm not saying, my lord, because when my proposal was sent for approval, my lord, the inquiry, if your lordship kindly see the, my lord, what my lord Rule 11 says, my lord, chapter 9, then clear, it will be clear, my lord. Rule 11, my lord.
Yeah.
Kindly see. Chapter 9 of Rule 11.
Yes.
If any person belonging to the classes of people notified under section 162 and mentioned in section 163 to A, B, and C is found in occupation of any wasteland, otherwise than in accordance with these rules, he shall be evicted. Then, my lord, provided that the deputy commissioner or officer empowered in this behalf may, after satisfying himself as to eligibility of the claim, the bona fide of the occupant, and availability of the land, offer settlement of the land in accordance with these rules after realizing the back revenue to be assessed from the date of occupation, my lord. Settlement, then the assessment of revenue for, my lord, for my occupation, my lord. If your lordship see the inquiry report, my lord, the Mondal has inquired, my lord, I am occupying that land, my lord, by paying the revenue, my lord, the other revenue, my lord, baki revenue, my lord. So the question of, my lord, by paying revenue from the date of my occupation, because I am occupying that land by paying revenue, my lord. So if your lordship kindly see the Rule 11, my lord, after the satisfaction by the deputy commissioner, when the proposal was sent, my lord, after consideration of my eligibility and my claim the bona fide right, my lord, and the honorable single judge hold that the no right accrued, my lord, unless it is approved, my lord. But herein is when the question of bona fide right comes into play, my lord, consideration, my lord. My bona fide right before approval is there, because if I have the bona fide claim, my lord, then, my lord, this process of eviction, my lord, under these rules, my lord, does not come, my lord. I may place one judgment of this division bench, my lord. Judgment claim.
Yes.
But, my lord, paragraph 6 of the judgment, my lord.
Yes.
Whether the appellants are legitimately entitled to make a claim requiring an impartial adjudication prior to any recourse being taken by responsible authority for eviction from the land is primarily issued to the answer in peculiar facts and substance of the present case. A perimeter provision of summary eviction under the Andhra Pradesh National Act so-and-so had received consideration from the Supreme Court in case of so-and-so. In the said case, the Supreme Court observed that although what is relevant for deciding on the question for resorting to summary remedy is more on the nature of the property on which encroachment is alleged to have been committed. However, duration of occupation is also relevant in the sense that a person who is in occupation of a property openly for a appreciable length of time can be taken prima facie to have acquired a bona fide claim to the property requiring an impartial adjudication according to the established procedure of law. In the instant case, notwithstanding the nature of the property on which the encroachment is alleged, the appellant has been in occupation for more than 100 years. It is for the reason alone, and having regard to the decision in Thamulera Krishna Rao, the appellant can be a legitimate claim over the land in question requiring an impartial trial and adjudication on the matter by following due process of law, my lord. My lord, so the honorable single just finding, my lord, prior approval, there is no right accrued by the, my lord, that is perverse, my lord. My lord. And my lord, if my lord, this is my lord, I am submitting, and my lord, the honorable apex court interpreted that the same move, my lord,
That you have already argued.
yes.
That's all. Close for orders. Order is up.
Obligement.
Close for orders.
Item 17.
Let. Another 15 December 2014. On 15 December 2014, the meter of the, my lord, the petitioner's mill meter is also sealed. The cabinet is sealed, my lord. And
Admit. Well, issue notice, admit issue notice, having heard the learned concept of the parties. Admit issue notice to parties. Notice on behalf of all the respondents, services therefore complete.
well, interim order may be there. Interim order may be there.
Interim order,
So, because 50% we have paid, my lord.
interim order, reject by speaking order करे या वैसे ही?
No, only, my lord, no coercive action. No
No
coercive action should be there.
by rejecting speaking order or coercing it.
Well, nothing, not required, man. Not
Yeah, the amount, whatever it is.
required.
Or do one thing,
Yes.
you pay the whole amount, that would be subject to the decision of this writ appeal.
Okay.
17 lakhs and something amount is due.
Let it be as it is, my lord.
Why let it be, then,
We'll take the remedies available to us.
initiate action to take money from it.
Item 18.
Pass over for the times.
Item 21.
Maybe not. One in time may be granted lot of high level objection.
Well, admit it and here the matter. Finally,
Kindly one if time may be granted.
huh?
One if time may be granted.
In between, they'll admit it. In between, you may file whatever you want.
My lord, after filing objection, matter may be admitted, madam. You may be allowed to file objection. After that, your lordship may admit.
You're free to do.
Only question of law is to be decided, madam.
Yeah, having heard the learned counsel for the parties, we are of the view that matter requires further consideration, hence admit. Issue notice, hence admit as the parties, as the respondents are represented through respective counsels, no formal notice are required to be issued. List in due court for hearing. In the meantime, if the parties, the respondents may file additional pleadings if they desire so.
The interim protection may continue, my lord. In usual course, it may take time, my lord. The date may be fixed, my lord, for hearing, because
How much
they are
time?
illegal, the
Appeal
committee
is
is
of the
illegal.
year 2024, okay, listed in 2027.
No, my lord, sorry, my
So
lord.
then it will come in routine court.
Because they are holding illegally the office, my lord.
Interim order passed by this court on so and so is made absolute till final disposal of on 22/7/2024 is made absolute till final disposal of
I'm grateful, my lord. Obliged.
this writ appeal.
Item 24.
NC is autonomous council, my lord. They do not have any legislative competency, my lord, for passing this anti-defection law. It is on the face where they've given their affidavit. In the affidavit,
And this NC council has given this affidavit.
yes. They say in public interest they have done it earlier. Some persons they have. On the face of it, my lord, the matter is pending, the bill is pending in parliament. Constitution to the court. Constitution.
Admit, having heard the learned counsel for the parties, we are of the view that matter requires consideration. Admit, no need to issue formal notices, parties are represented. List in due course.
All right.
For hearing.
24 minutes. I will not pay for 27.
No, you'll not pray. If you pray, then we'll list it in 27.
I thought of pressing for stay because on the face of it,
Ultimately, that, yeah, there is a point, but ultimately defection for the purpose of defection, if they have.
if there is legislative competency is not there, my
That
lord.
is there,
On the matter, a bill has been introduced in parliament.
That's why only admit. That's why admit. Matter requires consideration.
For hearing, item 25.
May please, my lord. My lord, on the last occasion, I had argued on the maintainability of the writ appeal, my lord, and my lord has asked me to address this court on the merit, my lord. And one pertinent question, my lord, which came from my lord was, my lord, that how is the quantum justified by the learned single judge? that quantum of rupees 10 lakhs. Now, my lord, when I was going through the judgment today, something strange had occurred, my lord. In the impugned judgment, which is before my lord's, my lords, there are two paragraphs which is missing. And these two paragraphs, in the reported judgment, my lord may take up the reported judgment. I've given the reported judgment. It's reported in 2019 7 GLR 654. Two important paragraphs, my lords. Paragraph 21 and 22. No? 21
Missing from where?
missing from the main records, my lords. I have checked the High Court again, my lords, the High Court website. When you get a printout from the High Court website, my lords, these two paragraphs are missing, which is very essential.
Which
My lord,
paragraph?
paragraph 20 and 21.
20 and 21.
And these two paragraphs, it contains the...
Just
Yes, my lords. My lord may tally it with the impugned judgment. Missing on the website as well. Check. Yes.
We can't rely on this.
My
Our
lord,
record is there.
that has to be verified by the
original
registry.
copy of the judgment is there.
But my lords, this is a reported judgment. 20 and 21 contains the reasoning, my lords, why the quantum has been.
Seems the reasoning, then how can we rely on this, sir?
My lord, some mistake, my lord, it has to be verified by the registry, which is the correct judgment, my lord.
Is the verification, the record is with us.
My lord, may kindly check
What-
20 and 21.
SB का फाइल मंगा लो.
P of 70 fall to P of 70. WP criminal.
These two paragraphs cannot be randomly added, my lord. It's authored by, my lord, may peruse the
Sir,
paragraphs.
offered by, we have a certified copy of
I
the-
understand,
and
my
we'll go through the original record.
Exactly, my lord.
And you have already checked it from the.
I've checked it from the website. Again, these two paragraphs are missing.
Then if these two paragraphs are missing, then it means in the original order, these two paragraphs are not there.
That I have to verify, my lord. The lordships have to verify. But the reported judgment, my lord, is reported in GLR as well, SCC online. These two paragraphs are there.
But sir, you are referring to para number in reported judgment, you are referring.
20 and 21, my lord. These two
21.
20 and 21. These two paras contain the reasoning, my lord. Why the quantum?
That is, these are here.
No, my lord, it's not there. It's
And
not there.
para number 18,
Para 20 is not there, my lord.
para 18 of the
Excellent.
judgment.
मेरे को क्या है?
Paragraph numbers change over paragraph.
No, paragraph numbers.
Para 18.
I'm coming to that one.
Para certified copy of the, as regards the grant of compensation under the public remedy.
No, my lord, I'm not referring to this paragraph. 21, my lord. 21. My lord may refer to 21. It is now well settled that monetary and pecuniary compensation for violation of fundamental right is one of the effective remedies under public law. However, while making such assessment of compensation, the emphasis is on the compensatory and not on punitive element, as the objective is to apply the balm to the wounds and not to punish the transgressor or the offender. This paragraph is totally missing, my lord. The long paragraph of judgment has also been cited, my lord. DK Bas. 22 is also missing, paragraph 22.
Even last operating portion is also missing. This within a period of 4 months, thereafter, within a period of 4 from the date of receipt of a certified copy of the order, and at least 5-6 lines are also missing.
The original judgment has to be referred to, Malad, the signed judgment. Because if the
The timing of it, confirm it first.
time being, Malad.
Item 26.
The very limited prayer, my lord. Move. Interim. My lord, as per inquiry commission, my lord, act, my lord, I have got the report, my lord, but only volume 1. When I go to the volume 1, it refers volume 2, which is not been provided to the anybody, my lord, that has not been placed. So my request at this stage is that my prayer is that, my lord, that they should furnish volume 2. That is a part of the report. And also, my lord, action taken. That is only 2 prayer right now.
Yes.
Well, the prayer made in the repetition is that the report has to be made public. It is made public. Malad. Some copy they have given that they have already got. Malad. They have said that some they have not received. That Malad, I'll verify. As regard the action taken, Malad, already we have filed an affidavit, and Malad, series of writ appeal is pending, and some series of writ petition is also now has come up. The action has been taken. Criminal cases are also going on against the persons, Malad, who are found guilty.
Approved by the legislature or not?
Yes, Malad. It was placed before the cabinet. Cabinet has approved.
It was placed before it.
On 17th of February, when it is placed, and is now it has been adopted, accepted.
Accepted? No. Not accepted.
I downloaded the report, my lord. The report, my lord, it says about volume 2, but volume 2 is not not even in the website.
पता कर लो volume 2 है या नहीं है?
Not about.
If it is there or not. Maybe
No, it is not there. It is not there.
No, it says, but in fact, is there any volume 2 or not?
Yes, in that I'm flag back reading myself. Every document says, my lord, volume 2, volume 2, volume 2.
Volume 2.
I'll get that information. That information I'll get.
Send it.
Lot.
Yes.
Passover meter 2.
Return of notice of unsought respondent for 6 more people.
Item 18, passometer.
Earlier, the petitioner was directed to take the paper publication to serve notice upon the respondent.
Present for the petitioner. PL petitioner, even in second round. In the interest of justice, the matter is adjourned. Just in July.
Item 25. Item 25.
Original file, we are not in this.
Something can be missing, but something cannot be added normally. If there are 2 paragraphs.
That is to be confirmed.
Yes, yes. Otherwise, it has to be deleted from the reported judgment also. Ma'am.
Oh, what happened? Let the.
And some other day, my lord.
See to it tomorrow.
Tomorrow.
Check.
Any other day but tomorrow, day after tomorrow.
So we have to just confirm it. What is that? It's very serious matter.
Yes, yes, yes.
We have to confirm tomorrow.